Even where there has been an endeavor to give preeminence to the central legislature in cases of a conflict of powers, it is obvious that in some cases where this apparent conflict exists, the legislature could not have intended that powers exclusively assigned to the provincial legislature should be absorbed in those given to the central legislature. Kindly keep that in mind. Then, Lord, they refer to the para 42. The federal structure under the constitutional scheme can also work to nullify an incidental encroachment made by the parliamentary legislation on the subject of a state legislation where the dominant legislation is the state legislation. An attempt to keep the aforesaid constitutional balance intact and give a limited operation to the doctrine of federal supremacy can be discerned in the concurring judgment of Ruapal J in ITC Limited versus Agriculture Produce Marketing Committee. This is a constitutional benchmark, wherein after quoting the observations of this court in SR Vimai, the learned judge had gone to observe as follows. The fact that under the scheme of our constitution, greater power is conferred upon the center vis-a-vis the states does not mean that the states are mere appendages to the center. May I pause here? I recall what Lordships had observed in Delhi matter. Lord. States are not satellites and appendages of the center. They have their own unique sphere defined by the constitution. Within the sphere allotted to them, states are supreme. Center cannot tamper with their powers. More particularly, the court should not adopt an approach, an interpretation which has the effect of or tends to have the effect of whittling down the powers reserved to the states.
The next down to whether
But the next paragraph is equally important.
Yeah.
Although Parliament cannot legislate on any of the entries in the state list, it may do so incidentally while essentially legislating within the entries under the union list. Conversely, the state legislature may encroach on the union list, which, when such an encroachment is merely ancillary to an exercise of power intrinsically under the state list. The fact of encroachment does not affect the wires of the law, even as regards the area of encroachment. This principle, commonly known as doctrine of pith substance, does not amount to an extension of the legislative field. Therefore, such incidental encroachment is either event does not deprive the state. Such incidental encroachment in either event does not deprive the state legislature in the first case or Parliament in the second of their exclusive powers under the entry so encroached upon. In the event the incidental encroachment conflicts with the legislation actually enacted by the dominant power, the dominant legislation will prevail. Otherwise, the entire concept would be anti-federal.
Yes. What else, Mr.
Now, Lord, what I was submitting here is, and I'll run through it very fast. I had already placed large portions of my written submission, but so far as it is based on the legal history in the legal sense, Lordships can look into it. But I would not read the entire thing because it would be just repetition of what I had.
Tabulated statement, which was
Page 16 to 16 to 22. And I have referred those principles which I have evolved with case laws now. Hmm? And this case law, which is specified point-wise, buttresses what I'm arguing. But then eventually, not what I would submit with respect is the last of these, page 22, the last paragraph, no? Therefore, any declaration have not got it?
Yes.
Page 22. Therefore, any declaration under entry 52 list 1 only draws jurisdiction from entry 24 list 2 and cannot affect state legislature's power under any entry other than entry 24 list 2. This is settled position by various constitution benches of this court. Entry 24 is a general entry while special entry are excluded from it. This is also settled by the above judgments, particularly the following. 62 is a very clear-cut case in this regard, because it pertains to, as I had shown, entry 25 list 2, gas and gas works. IDR took over that. He said you can't do that, and they struck down. Likewise, about 80 volume 4 SCC 136. This is a case Ishwari Khetan, where issue was acquisition of a company, read into entry 43 list 3. So they said entry 52 cannot take over the power from entry 42 list 3. Then note 81.4 SCC 391. This is Southern Pharma law, where again medicinal and toilet preparations were held to be within intoxicating liquor, as defined in Valsara. Medicinal toilet preparations containing alcohol, they were held to be within intoxicating liquor. Then note 96 volume 3 SCC 709 is extremely critical. Considers this argument in detail and then holds that entry 8 cannot be taken over under entry 52. Now, of course, that case was of a potable liquor. But then what applies to potable liquor will equally apply to non-potable liquor if intoxicating liquor includes industrial alcohol. So this is a direct authority which will help our cause. And last of all, without wasting lots of time, I would pray kindly allow me to place this judgment, 2002, 9 SCC.
Could you also see 96 for a moment? I mean, I think, since you said it's very...
Would you Lordship like to see?
Just for 2 minutes, let's have a look at it.
Volume 5, PDF page 2036. And paras are 25 to 38.
Mr. Really, why are you going to your bound volume when it comes to the cases? You're going that far, on your pleadings.
There's a slight kink in the mind, Lord, that we underline it while reading. So when something comes without underlining, I feel absolutely.
But you can underline. We underline all the time over here when you are reading, because when you are dictating the judgment, you look at what you underline.
Follow what Lordship's saying. I'll follow that.
You'll be able to underline as well. I'm sure your junior will tell you that little trick.
No, I have not. I have all the equipment.
You have the stylus and everything. But even without the stylus, you can underline.
Yeah, that's true.
2036, volume 5, is it?
Man.
Right. No, that is McDowell.
McDowell.
All right, 96.
This is a case, particularly in relation to potable alcohol.
Para?
Yes, 25 to 38. Para 25. PDF page is 2054. (25 to 38). This would also greatly answer Justice Nagaratna's problem that rose time and again. This will answer that question. Entries aforementioned disclose the following features. They refer to those entries, not entry 33, 52, Lordship will see in the earlier paragraph. Entry 8, paragraph 23. We may now notice the relevant entries in our constitution. Entry 6, 8, 6, 24, 51 in list 2 of the 7th schedule to the constitution read thus. Lordships have already seen, so I have not wasted Lordship's time on that. Entry 33 in list 3 was substituted by Constitution 3rd Amendment Act 1954. The background to this entry is explained by this court in Tika Ram versus State of UP. Entry 33 of list 3 reads, trade and commerce in and production, supply and distribution of the A products of any industry where the control of such industry by the union is declared by Parliament by law to be expedient in the public interest and imported goods of the same kind as such products. Foodstuff, edible oil including cattle fodder, raw cotton, Lordship, but that we are not concerned with that. But foodstuff, Lordship may keep in mind because I'll refer to that later on. The aforementioned disclose the following features. The power to make a law with respect to industries lies with the states. Entry 24, list 2. But the said entry is made expressly subject to the provisions of entry 7 and 52 in list 1. It means that if Parliament declares by law that it is expedient in public interest to take over the control of a particular industry or industries, such industry or industries get transplanted to list 1. In other words, the industries in respect of which Parliament makes a declaration contemplated by entry 52 in list 1, the states are denuded of the power to make any law with respect to them under entry 24 list 2. Parliament has indeed made the declaration contemplated in entry 52 in list 1. In section 2 of the IDR Act, which reads, the declaration as to the expediency of control by the union, it is hereby declared that it is expedient in the public interest that the union should take under its control the industries specified in the first schedule. By an amendment effected in 56, first schedule was amended. The Amendment Act inter alia introduced entry 26 in the scheme. It reads fermentation industry, alcohol and products of the fermentation industry, other products of fermentation industry. The contention of the Learned Counsel for the petitioners is based upon these provisions. The submission is that manufacture and production of intoxicating liquor is an industrial activity falling within item 26 of the first schedule to the IDR Act. The IDR Act provides for licensing of industries mentioned in the first schedule to the Act, besides providing extensive control and regulation of such industries and their products. The grant, the renewal and the refusal to grant or renew the license is thus the exclusive province of the centre. The state has no say in the matter. The state legislature is incompetent to prohibit manufacture of intoxicating liquors. But this argument, in our opinion, ignores the existence and the ambit of entry 8 in list 2. Entry 8 expressly speaks of production, manufacture, possession, transport, purchase and sale of intoxicating liquors. It means that the power to make a law with respect to the said matters rests with the state legislature. What is significant is that the entry speaks expressly of production and manufacture of intoxicating liquors as well. This would mean that the industries producing and manufacturing intoxicating liquors fall within the purview of entry 8. May I pause here? Lordships must keep this in mind that this judgment is under the shadows of synthetics too. It said that you don't have power in respect of industrial alcohol. You can only regulate potable alcohol. So it is under the shadow of that judgment that they are referring to. Applying the well-known rule of interpretation applicable to such situations specially excludes the general. We must hold that the industries engaged in production and manufacture of intoxicating liquors do not fall within entry 24, but do fall within entry 8. This was the position at the commencement of the Constitution, and this is the position today as well. Once this is so, the making of a declaration by Parliament as contemplated by entry 52 of list 1 does not have the effect of transferring or transplanting, as it may be called, the industries engaged in production and manufacture of intoxicating liquors from the state list to union list. As a matter of fact, Parliament cannot take over the control of industries engaged in the production and manufacture of intoxicating liquors by making a declaration under entry 52 of list 1. Since the said entry governs only entry 24 list 2 but not entry 8 list 2. Faced with the above position, learned counsel for the petitioner resorted to more than one argument to get over it. Firstly, it was submitted that the entries 24 and 8 should be read harmoniously, and that such harmonious reading should mean that the industries engaged in production and manufacture of intoxicating liquors would fall within entry 24, because entry 24 deals with industries as such, while entry 8, according to such reading, would be confined to matters other than production and manufacture of intoxicating liquors. It is not possible to agree with the submission which run counter to the express language of entry 8. It requires us to delete the word production and manufacture from entry 8, which is not open to us. We cannot rewrite the entry. Another limb of this argument was that only those entries manufacturing intoxicating liquors which are not within the purview of IDR Act will fall under entry 8. Now kindly see the reading the definition of industrial undertaking clause D and the defining of factory in clause C of section 3 of the IDR Act. It is submitted that the two types of industries are not covered by IDR Act vis-a-vis those where manufacturing process is carried on, one, with the aid of power but with less than 50 workers, and without the aid of power with less than 100 workers. The submission is that these industries which are not within the purview of IDR Act would remain within the purview of entry 8, while the other industries would be under the control of the union. This argument is equally unacceptable. This argument is premised on the assumption that entry 52 in list 1 overrides entry 8 in list 2, as which assumption as we shall presently point out is without a basis and unacceptable. Moreover, industries which are exempted from IDR are exempted because the very provision of the IDR Act and not by virtue of entry 8 in list 2. The ambit and scope of constitutional entry cannot be determined with reference to the parliamentary enactment. The definition of factory in clause C of section 3 of the IDR Act may be changed tomorrow. The meaning and scope of entry 8 in list 2 does not and cannot vary with the change in the provisions of IDR. This submission too is therefore unacceptable. It was then contended that entry 52 list 1 governs not only entry 24 in list 2 but all other entries in list 2 including entry 8 insofar as it deals with industries. We cannot accept this submission either. A perusal of list 2 would show that whenever a particular entry was intended to be made subject to an entry in list 1 or list 3, it has been so stated specifically. Not one but several entries in list 2 are made subject to one or the other entry in list 1 or list 3. See entry 2, 13, 17, 22, 23, 26, 27 and 33. Certain other entries use a different phraseology to demarcate the sphere of the union and the state. For example, entry 32, incorporation, regulation and winding up of the corporation other than those. Likewise, note entry 51 list 2. All this shows that whenever a particular entry in list 2 is sought to be made subject to another entry in list 1 or 2, or where a demarcation is sought to be made between union and the states within a particular head of legislation, the founding fathers have taken care to say so expressly. We cannot therefore accept the argument of the learned counsel for the petitioners in that entry 52 in list 1 impinges upon, overrides and governs entry 8 in list 2 as well. It does not. We must make it clear that entry 8 speaks of only intoxicating liquors and does not therefore apply to or take in liquors which do not fall within the expression intoxicating liquors. The power to make a law with respect to production and manufacture of intoxicating liquors is that of the state alone. The prohibition of production and manufacture of intoxicating liquors too squarely falls within four corners of entry 8, read with entry 6 of list 2. This was the decision of the Constitution Bench in Code Distillery. Article 47, then they refer to, then Lordship have, they refer to
37, straight away.
37.
Yes.
Man,
That will cover Kolkata Gas Company.
my lord. I'm
May
great.
not read again, but
We may, in this connection, and this is the first case where this principle was evolved.
Correct.
We may, in this connection, refer to Constitution-based discussion, this decision of this court in Calcutta Gas versus State of West Bengal, which furnishes a complete answer to the petitioner's contention on this court. The West Bengal legislature passed an act, West Bengal Oriental Gas Company Act 1960, with a view to take over the management and control of the undertaking of the Oriental Gas Company. Notifications were issued under the Act taking over the company, which was questioned by way of a writ petition in Calcutta High Court. The writ petition was dismissed, whereupon the matter was brought to this court. The main contention on behalf of the appellant was that the West Bengal legislature has no legislative competence to enact the said act. It was submitted that by virtue of Industries Development Regulation Act 1951, which contains a declaration in terms of entry 52 in list 1 and the schedule thereof, included fuel gas, coal gas, natural gas, and the like. Under item 2.3, the power to make law with respect to those industries engaged in the manufacture of gas has been vested in the union, and that state has been totally denuded of that power. It was contended that entry 24 in list 2 takes in all industries, and that entry 25, which reads gas and gas works, should be confined to matters other than those covered by entry 24. Inasmuch as impugned enactment was a law relating to gas industry, it was submitted the act made by the state legislature is incompetent and void. Reliance was also placed upon Article 246 of the Constitution. All these contentions were negatived after referring to the provisions of IDR Act and the impugned West Bengal Act, the relevant entries in the 7th schedule to the Constitution, including entries 7 and 52 in list 1, entries 24 to 27 in list 2. And the principle governing the interpretation of the entries in 7th schedule, the court indicated that the matter was susceptible to 3 possible constructions. Entry 24 of list 2, which provides for industries, generally covers the industrial aspect of gas and gas works, leaving entry 25 to provide for other aspects of gas and gas works. Entry 24 provides generally for industries, and entry 25 carves out of it the specific industry of gas and gas works, with the result that the industry of gas and gas works is excluded from entry 24. And 3, the industry of gas and gas works falls under both the entries, that is, there is a real overlapping of the said entries. The court opined that having regard to the well-settled principles relating to interpretation of these entries, that interpretation which reconciles and harmonizes the contending entries should be adopted and held. And entry 24 in list 2 in its widest amplitude takes in all industries including that of gas and gas works. So too entry 25 of the said list comprehends gas industry. There is therefore an apparent conflict between the two entries and they overlap each other. In such a contingency, the doctrine of harmonious construction must be invoked. If industry in entry 24 is interpreted to include gas and gas works, entry 25 may become redundant. And in the context of succeeding entries, namely entry 26 dealing with trade and commerce and entry 27 dealing with production, supply and distribution of goods, it will be deprived of all its content and reduced to useless lumber. On the other hand, the alternative contention enables entries 24 and 25 to operate fully in their respective fields. While entry 24 covers a wide field, that is the field of the entire industry in the state, entry 25 dealing with gas and gas works can be confined to a specific entry, that is the gas industry. It is therefore clear that the scheme of the harmonious construction suggested on behalf of the state gives full and effective scope of operation for both the entries in their respective fields, while that suggested by the Learned Counsel for the appellant deprives entry 25 of all its content and makes it redundant. The former interpretation must therefore be accepted in preference to the latter, in this view, gas and gas works are within the exclusive field allotted to the state. On this interpretation, the argument of the Attorney General that under 246 of the Constitution, the legislative power of the state is subject to that of the Parliament, ceases to have any force for the gas industry is outside the field of legislative field of Parliament and is within the exclusive field of the legislature of the state. We therefore hold that the impugned act was within the legislative competence of the state Bengal legislature and was therefore validly made. The court proceeded to hold further. Lordship, over the rest, it's a repetition rest not when then again the ratio of the above decision fully supports what we have said here and before. In fact, entry 8 is more specific than entry 25 in list 2, while entry 25 merely speaks of gas and gas works. Entry 8 expressly speaks of production and manufacture besides possession, transport, purchase and sale of intoxicating liquors. The ratio of Calcutta gas case fully supports our conclusion that the industries engaged in production and manufacture of intoxicating liquors are outside the purview of entry 24 and fairly squarely fall within entry 8 in list 2 and that entry 52 in list 1 does not override or impinge upon entry 8 in list 2. According to this decision, the expression industry in both entry 24 and entry 52 in list 1 must carry the same meaning, which means that if a particular industry is not within the purview of entry 24 in list 2, it would not equally be within the purview of entry 52 list 1. The decision also supports our conclusion. Article 246 cannot be invoked to deprive the state legislature of the powers inhering in them by virtue of entries in list 2, to wit, once enactment in pith and substance is relatable to entry 8 in list 2 or for that matter any other entry in list 2, Article 246 cannot be brought in to yet hold that state legislature is not competent. Now what is important here again is what is but what is important is not that all these decisions are based on what we call the word industry. Not one word industry in entry 24, as the judgment say, has the same meaning as in entry 52. But what is the scope of this word industry? And that is where Tika Ram ji is the locus classicus.
Yes.
Which is 1956. Is it 1956 SCR 393 volume 5. PDF page 80. 80. And this Tika Ram ji's case still holds the field. And
Mr. Dwivedi,
Man.
you read, we discussed Calcutta Gas Company, right?
Man.
That is volume 5, page PDF 2149. Just come to that judgment,
Great.
para 9, where Tika Ramji is elaborately discussed.
Yes.
That will give a fair idea.
Lordship's right, no? Tika Ram ji was considered by Calcutta Gas, no? And that is for the word industry.
9, para 9 at PDF 2158.
I'm grateful. About 2158.
15 lines
2158, right.
in the
Para 9.
descending order.
First question that occurs, if I may place, no?
Yes.
Lordship's permission. The first question that occurs to one.
Because this thing, which page you are reading? In volume?
2158.
2158. PDF page 2158.
9.
Volume 5.
2150.
2150.
2150.
Yeah. And we are at 2150.
2158.
PDF page 2158, which is,
PDF 215.
that's a whole confusion. Page. The first question, if I may place here. May I place it?
Yes.
The first question that occurs to one's mind is, what is the meaning of the expression industry in entry 24 of list 2? Is it different from the meaning of that expression in entry 52 of list 2? Whatever may be its connotation, it must bear the same meaning in both the entries, for the two entries are so interconnected that conflicting or different meanings given to them would snap the connection. Entry 24 is subject to the provisions of entry 7 and 52 list 1. Entry 7 of list 1 provides for industries declared by Parliament by law to be necessary for the purposes of defense or for the prosecution of war. And entry 52 for industries, the control of which by the Union is declared by Parliament by law to be expedient in the public interest. Therefore, ordinarily industry is in the field of state legislation, but if Parliament by law makes a relevant declaration or declarations, the industry or industries so declared would be taken off its field and passed on to Parliament. In the premises, the expression industry in all the entries must be given the same meaning. Now, what is the meaning of the word industry? In Tika Ram state of UP, the expression industries is defined to mean the process of manufacture or production and does not include the raw materials used in the industry or the distribution of the products of the industry. It was contended that the word industry was a word of wide import and should be construed as including not only the process of manufacture or production, but also activities antecedent thereto, such as acquisition of raw material and subsequent thereto, such as disposal of the finished product of that industry. But that contention was not accepted. It is not necessary in this case to attempt to define the expression industry precisely or to state exhaustively all its ingredients. Assuming that the expression means only production or manufacture, would it take within its sweep production or manufacture of gas? Entry 24 in list 2 in its widest amplitude takes in all industries, including that of gas and gas works. So too, entry 25 of the said list comprehends gas industry. There is therefore an apparent conflict between the two entries and they overlap each other. In such a contingency, doctrine of harmonious construction must be invoked. Both the learned councils accept the principle, while the learned Attorney General seeks to harmonize both the entries by giving the widest meaning to the word industry, so as to include the industrial aspect of gas and gas works and leaving the other aspects to be covered by it. I may not place because it's covered under the McDowell, the Lordship have already seen that. But the critical part in Tika Ramji's consideration is not entirely here. And therefore, what I want to do is not to cut short time instead of reading all those decisions. There are at least 5-7 constitution benches in that sphere. So it will be wasting time. There's one judgment of a lordships which deals with all of them, Lord, and synopsizes all those cases. Right from Tika Ramji onwards till ITC, this judgment. And this is still holding the field, Lord. There's no dispute with regard to this.
Were you referring to this? I was reading the original Tika Ram ji. industry in the wide sense of the term would be capable of comprising three different aspects. Were you reading that part? Yes. I'm on Tika Ram.
No, that was very well dealt with in Tika Ram ji. All the matters, all the aspects of industry, they noted one.
If you see para 24 at volume 5, page 96, volume 5, Tika Ram ji begins at page 80. Yes. And if you see para 24, actually that's a crucial part of Tika Ram ji. See, there the question was whether the process of acquiring sugarcane, which was a raw material for the manufacture of sugar, whether that would be covered within the ambit of industry.
That they said would fall as goods under entry 26.
So just let's see that. Para 24 is important actually at page 96, PDF page 96.
This is
Yes. The passage begins as, it is clear therefore,
Page 88.
Yes.
I have lots of got.
Yes.
yes.
It is clear therefore that all the acts and the notifications issued thereunder by the centre in regard to sugar and sugarcane were enacted in exercise of the concurrent jurisdiction. The exercise of such concurrent jurisdiction would not deprive the provincial legislature of similar powers which they had under the provincial legislative list. And there would therefore be no question of legislative competence. Incompetence qua the provincial legislatures in regard to similar pieces of legislation enacted by the latter. The provincial legislatures as well as the central legislature would be competent to enact such pieces of legislation, and no question of legislative competence would arise. It also follows as a necessary corollary that even though sugar industry was a controlled industry, none of these acts enacted by the centre was in exercise of its jurisdiction under entry 52 list 1.
Now actually what follows is very important. Industry in the wide sense.
In the wide sense. Industry in the wide sense of the term would be capable of comprising three different aspects. One, raw materials, which are an integral part of the industrial process. Two, the process of manufacture or production. And three, the distribution of the products of the industry. The raw material would be goods, which would be comprised in entry 27 of list 2. The process of manufacture or production would be comprised in entry 24 of list 2, except where the industry was a controlled industry, when it would fall under entry 52 list 1, and the products of the industry would also be comprised in entry 27 of list 2 as goods. Except where they were the products of the controlled industry, when they would fall under entry 33 list 3. This being the position, it cannot be said that the legislation which was enacted by the centre in regard to sugar and sugarcane would fall within entry 52 of list 1. Before sugar industry became a controlled industry, both sugar and sugarcane fell within entry 27 of list 2, but after declaration was made under entry by Parliament under 1951 by Act 65 of 51, sugar industry became a controlled industry, and the product of that industry, whether sugar, was comprised in entry 33 of list 3, taking it out of entry 27 of list 2. Even so, the centre as well as the provincial legislatures had concurrent jurisdiction in regard to the same. In no event could the legislation in regard to sugar and sugarcane be thus included in entry 52 of list 1. The pith in substance argument also cannot be imported here for the simple reason that when both the centre as well as the state legislatures were operating in the concurrent field, there was no question of any trespass on the exclusive jurisdiction vested in the centre under entry 52 of list 1. The only question that survived being whether putting both the pieces of legislation enacted and the state legislature together, there was any repugnancy in issue. And here they found there was no repugnancy because there was no central law. The conflict has to be in fact, this is the judgment which for the first time said. There has to be a conflict in fact, and therefore you've got to legislate under the IDR Act to control this. But then the interesting part of it is not this, which Lordship may bear in mind, but kindly come to entry 33. More than that. But there is one interesting factor which Lordships may take into consideration here, again, which
Difference in Tika Ram was concerned with the control over the antecedent raw material. Over here, we are not dealing with a control over the antecedent raw material. This is the heart of the industry.
but the word industry was considered and the scope of word industry was found. No, but important part is why. Question was that is Tika Ram is a case where on the one hand there was
Actually, but for entry 8 of list 2, industrial alcohol would fall within the ambit of industry in entry 52 of list 1.
how would it fall? But this is a question
But for entry 8.
I'm coming to
It's an industry.
I'll answer that. No? Then we would at the same time be saying that intoxicating liquor would be only potable liquor and industry pertaining to potable liquor would exclusively go to entry 8.
No. That's not, you have understood the purely. I'm saying that it is because of entry 8 that
It would not go into
entry 8 that doesn't go into entry 24 and doesn't go into entry 52. But if entry 8 was not there,
then it could have been.
it would have been an industry then within entry 52 of list 1.
Yes, no doubt about it. No doubt about it. Important thing is not entry, the Tika Ram ji.
Challenging the idea. So what is the ambit of the expression
I'll answer that. No?
fermentation?
In
And
the Lordship has Malot kindly again go back.
you have what is the schedule?
No, there are two answers to what Lordship's query is. No? I'm sorry.
What would be the difference between intoxicating liquor and alcohol?
Not every intoxicating liquor, as per the local acts Lordship has seen, meant all liquids containing alcohol. So every alcohol will have to be there.
Because under the entry 26 of the schedule,
Well, it's a changed entry.
one is
It's a modified entry.
alcohol.
This has been modified in 2016, where because of Bihar distillery, they carved out an exception not against potable alcohol, which was not there earlier. When these cases were considered, McDowell, Tika Ram, the position was entirely different. Only fermentation industry was specified with alcohol, word alcohol.
What is the entry before the 16?
That is substituted in
2016.
The only thing within the brackets were omitted.
That's
It
right.
was fermentation
Fermentation
industry, and then
industries.
one into the products, alcohol and other products of
also
fermentation.
fermentation.
Yes.
So other than potable alcohol was added by the
2016, that are in
2016.
It was earlier fermentation industries.
And then
That bracket portion was added.
Acts of fermentation industries would take an intoxicating liquor.
Normally, fermentation industry, that was the interpretation given to it. But the whole question is, can you take it? That's a question, can the Parliament take it? Now, to answer the Chief Justice's query, no one has challenged. There's no doubt about it. No one has challenged the inclusion of fermentation industry. There's no doubt about it. But in Calcutta gas, no one had challenged it. No. Yet the court struck down that on the ground that we are deciding and deciphering the scope of legislative entry. So if the act of another two legislatures do not fall within that entry, then they have to go. The dominant legislature has to prevail. Likewise, my lord, in ITC, again the same thing was done. This objection was raised that no one has challenged the IDR Act. But the whole question would be that if the Parliament legislates,
Because if you accept your submission, I mean, not that we are saying that it's wrong, just trying to explore it. That would mean that where any industry is specified in list 2, that would include gas works, that would include intoxicating liquor, that will fall outside entry 52 of list 1.
52 of this.
Isn't it?
Entry 54 is mines and minerals.
Sorry?
Lordship has done the mines and minerals matter that entry 54 occurs in Lordship's
52, 52.
52. It would be outside that.
No, but then why does Parliament cover
That's the
prior to 2016? Parliament covers the entirety of alcohol.
yes. But the whole issue is whether that is correct or not, because lordships are defining the scope of the entry and Parliament is legislating on an entry which is not there in their field. So how can legislation without power is a void legislation, still born?
But you're appearing for whom?
State of UP. But we are the petitioners actually sitting on the wrong side actually, that's the problem.
But are you saying therefore that the legislation which is enacted by Parliament is
Otherwise we can't get the jurisdiction, Lord. Can you look at it this way? State's jurisdiction has been denied by synthetics on these great grounds, entry 52. Now, if we do not challenge that, synthetics cannot be overcome. If synthetics cannot be overcome, then what are we, due respects, reconsidering? We are considering whether synthetics, when it relies upon entry 52 to shut down state's jurisdiction in respect of intoxicating liquor, which includes industrial alcohol, that is incorrect and state's jurisdiction cannot be taken away. Synthetics took away because of entry 52 and IDR. Lord, I'll satisfy lordships on this issue that I need not challenge. If the question arises during consideration, what is the scope of the legislative entry? And if there is any conflict, the lordship will have to resolve the conflict. And if the lordships resolve the conflict in the manner I am advocating, perhaps not, then the question would be clear that centre had legislated absolutely illegally. Otherwise, more lordship would seem, Lord, even though state has jurisdiction under entry 8, yet because of parliamentary declaration or legislation, we are denied the power to legislate on our own field. Lord, whatever is troubling lordship that no one has challenged IDR, Lord, was answered by ITC.
legislated
Exactly.
on an industry which falls within the scope of entry 8 of list 2?
Exactly.
Because alcohol,
Well, that is assuming it falls. My lord, industrial alcohol, if it is part of intoxicating liquor, then what Lordship is saying is correct. But if it has, then what will be the consequence? And the aspect that is troubling a Lordship, sir, that since no one has challenged IDR and it has been prevailing, then what can be done? No, that is answered by ITC. We need not challenge it. When Lordships determine the scope of the entries, then the power of the state with respect to its own entry cannot be declined because Parliament has declared something. Otherwise, tomorrow Parliament will take over gas and gas works, then what happens?
See, because Article 246(1), it begins with a non-obstante clause,
Right.
notwithstanding anything contained in clauses 2 and 3.
Right.
Clauses 2 is with regard to state list. Clauses
Subject-
3 is with regard to, clauses 2 is with regard to concurrent list. Clause 3 is with regard to state list. Notwithstanding anything contained in the concurrent list and the state list, Parliament has exclusive power to do it with regard to union list.
Right. Now, let me explain it not this way. Lordship saw in that case of Lord Jayant Verma, the word notwithstanding is a concept which only emerges when there is an irreconcilable conflict. First, the effort should be to reconcile the conflict if it appears. The Parliament may have legislated on A entry or B entry. But the fact is, what we have to see is whether that legislation is within its field or not. And likewise, state legislation within its field or not. Now, when we find that there are two entries which are overlapping, for instance, industry,
Yes.
gas and gas works, they were overlapping. The court found in McDowell as well as Calcutta Gas. Now, if they were overlapping, then Lordships have to evolve some principles of harmonious construction. Notwithstanding
The other harmonious way would be to say that yes, the state does have the power over intoxicating liquor,
Quite right.
but once there is a declaration made by Parliament under entry 52,
That power is
then
taken.
your power is denuded.
Then that, which means entry 8 list 2, even though it has not been made specifically subject to entry 52, it becomes subject to like entry 24. So what are we saying is that we are reading word subject to in entry 8, which perhaps it is not open to read.
Then what is the meaning to be given to the expression notwithstanding anything contained
Not,
in Article
I'll answer that.
246(1)?
Quite right. I'll answer that. Notwithstanding means not in case the conflict is irreconcilable harmoniously, then in that even parliamentary entry would prevail over the state entry. But the fact is, when your Lordships can reconcile harmoniously, as Lordships have done in the case of McDowell and Calcutta Gas, then perhaps notwithstanding clause would not operate.
That is the question.
No, but in every case, that's,
Whether we can narrow the scope of the expression industry in entry 52 list 1.
not entry 24 list
Entry
1.
52 list 1.
I'll answer. For that, not the answer was there in this McDowell's case. Entry 52 draws from entry 24. Now, what we have to see, what is the position in the state list with regard to word industry in the state list. Now, in the state list, industry means what that has been determined in Calcutta Gas as well as McDowell. It means only manufacture. It would not include entry 26, 27 or any other entry that is not subject to it. For instance, Calcutta Gas entry 25, that is also in industry, like entry 8. Now, Calcutta Gas Union took over the jurisdiction by specifying it as an IDR, under the IDR in the schedule. Now, despite the fact they had specified in the IDR the gas and gas works, yet the court said when we look into the entries that are there, what appears to be is that the word industry in state list which would exclude those entries which are independent of and are not subject to entry 52. For instance, gas and gas works is not subject to. But if the Parliament can still take it over, then what is the point in specifying 25 list 2 separately? It could have been there in the word industry.
Right.
So long it is not taken over by the parliamentary law, it will be remain with the state list. But once it comes under the
long it-
IDR Act, what happens?
I think there's one thing which has been missed, Lord. I would give submit with due respect. Lord, so long it is not taken over, but what can be taken over is only what is there in industry. That is entry 24. It cannot take over something which is not there in entry 24. Now, our submission is, with the support of McDowell and the other cases, that entry 24 will not include entry 8. That is what McDowell says. And it will not include entry 25. That is what Calcutta Gas says. If word industry does not include that, then you can't take it over. Parliament cannot take it over. Power of Parliament is not entirely, absolutely wide and expansive. Parliament's power cannot run amok over the state list, except so far as word industry in entry 24 is concerned. So it is 24 only which is subject to deprivation on the declaration. No other entry.
Other side on that.
Read something.
What else now remains?
Lord, I really wanted to read this judgment, Lord, which is this ITC, Lord, 2002, volume 9, SCC 232. 2002, 9 SCC 232. This is volume 5, CDF page 1597. This would clarify all the queries that have fallen from your lordships, Lord, and therefore I wanted to.
So I think volume 5.
If I may indicate the paragraphs, para 10, I'll give the paragraphs which are relevant for my purpose. Para 10, 26 to 31 or 26 to 32, 40 to 86. And this deals with the entire history with regard to the word industry, entry 52, as well as entry 24.
This is in volume 5, 1597.
Yes. So instead of reading all these decisions, this has the judgments, all the judgments, Constitution bench judgments in the synopsized form. To give the gist of the dispute, note, can you come to PDF page 1617? Now, in this case, the minority judgment holds the in favor of the union that the incidental encroachment would take away the power of the state. In the proposed judgment, this is the minority judgment part, and Justice Sabharwal's judgment is the majority judgment. In the proposed judgment, Justice Patnaik has held that the word industry in entry 50.
Just tell us the para once again.
Para 10, PDF page 1617.
We are now referring to Justice Sabharwal's judgment, right?
Justice Sabharwal's judgment. Chief Justice Sabharwal, in fact.
Yes.
His lordship as his lordship then was. No, I'm sorry, he was not the Chief Justice at that time, Justice Bharucha was the Chief Justice. In the proposed judgment, Justice Patnaik has held that the word industry in entry 52 of union, and by the way, note, this will answer the other question too, completely. This will answer the other question too. Therefore, I chose this decision note that will save time. In the proposed judgment, Justice Patnaik has held the word industry in entry 52 of the union list cannot be given restricted meaning so as to exclude from its purview the subject of legislation coming within entry 27 or entry 14 of list 2. And thus, the parliamentary legislation, namely the Tobacco Board Act 1975, is constitutionally valid, and consequently the state legislation entitling the market committee to levy fee for sale and purchase of raw tobacco within the market area will not be operative so far as the produce of tobacco is concerned, and that the majority judgment in ITC case is correctly decided. Lordship, with the rest, kindly come to paragraph. Paragraph 26. It is PDF page 1621. Before considering the above noted decisions, it would be appropriate to make it clear that in these matters it has to be kept in view that this court is not examining a case where the field of legislation is in the concurrent list, to which Article 246(2) applies. This court is also not considering the case of an incidental trenching of field by one or the other legislature. The court is concerned with the question of legislative competence. We are examining a case where what has been questioned is the legality of the legislation in respect of a field in the state list, to which Article 246(3) applies. The validity and applicability of the state legislation in respect of field of legislation in the state list has come under cloud on account of legislation passed by Parliament in respect of field of legislation under entry 52 of Union List, namely Tobacco Board Act 1975. It is on account of this legislation containing declaration as contemplated by entry 52 of the Union List that doubts have arisen about the validity of the applicability of state legislation about the sale of agricultural produce of tobacco in market areas and levy thereupon a market fee, which aspects are in the field of legislation in the state field, entries 14, 27, 28, 66. Entry 24 of the list 1 is subject to entry 7 and 52 of list 1. We are not concerned in these matters with entry 7. The question here is to the effect of transfer of field of legislation under entry 24 of state list to the Union List, entry 52, on other fields in the state list, namely field of legislation under entries 14, 27, 28 and 66, and what in fact can be transferred. That's the question we are concerned with in this case. Now they refer to Bajnath KDM, not Lordship omit that. 28 also Lordship omit that. No? Kindly come to 31. Relying upon Ishwari Khetan's case, Mr. Shanti Bhushan contends that entry 52 has been equated with entry 54 of the Union List. Both sides have relied upon Ishwari Khetan. Let us examine that case. In Ishwari Khetan's case, the contention urged was that Parliament has made the Industrial Development and Regulation Act 51, for short IDR Act, in entry 52 of list 1 declaring control of sugar industry, and that industry goes out of entry 24 of list 2, and therefore the state legislature is denuded of the legislative powers in respect of sugar industry, and the impugned legislation was with respect to acquisition of sugar undertaking in sugar industry. The Attorney General has contended that the power to acquire property was derived from entry 42 of list 3. Ishwari Khetan's case involved a determination or scope of entry 52 of list 1 and entry 24 of list 2 only. The scope of these entries with respect to entries 26 and 27 of list 2 and entry 33 of list 3 did not fall for consideration. Paragraph 7, 8 and 11 of Ishwari Khetan, the Constitution Bench repeatedly pointed out that declaration in entry 52 of list 1 denudes the state legislature of the power to legislate under entry 24 list 2 only. Can you notice this one? Only. It was notified that sugar was declared industry. It was noticed, I'm sorry. The question posed was that it is however correct to say, is it however correct to say that once a declaration is made as envisaged in entry 52 of list 1, that industry as a whole is taken out of entry 24 list 2. The answer given by the Constitution bench was that it is not correct to say that once a declaration is made in respect of industry, that industry as a whole is taken out of entry 24 list 2. It was said that the industry as a legislative head finds place in entry 24 of list 2. The state legislature can be denied legislative power under entry 24 to the extent Parliament makes a declaration under 52, and by such declaration Parliament acquired power to legislate only in respect of those industries in respect of which declaration is made, and to that extent as manifested by the legislation incorporating the declaration and not more. Lordship would recall, initially Lordships had posed this question that entry 52 does not use the word to the extent. The bench further said that the legislative power of the state under entry 24 list 2 is eroded only to the extent the control is assumed by the union pursuant to the declaration, and the state legislature which is otherwise competent to deal with industry under entry 24 list 2 can deal with that industry in exercise of other powers enabling it to legislate under different heads set out in list 2 and list 3, and this power cannot be denied to the state. The extent of parliamentary legislation can only was seen only to determine how much is taken out from entry 24 list 2, and not for the purposes of laying down any principle that parliamentary legislation has to be seen to determine the extent of control and delineation of the power of the state legislature. To the extent the control is laid down by Parliament. Further, it was held that despite the parliamentary legislation, the state legislature can deal with industry in exercise of other powers in different entries in list 2 and list 3, and that power cannot be denied to the state. In this case, the court was examining whether the law of acquisition of sugar undertaking was referable to entry 24 list 2 or entry 24 list 3. 42 list 3, it was contended that the acquisition of property was referable to entry 42 list 3. The scope of the industry do not fall for examination in Ishwari Khetan's case. There is no discussion on the interpretation of the expression industry, and that probably is the reason why Tika Ramji's case has not been referred to. The reliance of Baijnath KDO in Ishwari Khetan's case was to show the denudation of the state's power being limited to the extent of control. While Baijnath KDO dealt with entry 23 list 2, Ishwari Khetan case dealt with entry 24 list 2. The subject matter of other entries was not an issue in the decision. The structure of entry 54 of list 1 was not equated with that of entry 52 list 1 as contended by Shri Shantibhushan. This decision does not adopt the mines and mineral cases for the purposes of considering the scope of entry 52 list 1. In our view, the case of mines and minerals are not of much assistance while examining the scope of entry 52 list 1. In State of AP versus McDowell, also it was held that the ambit and scope of the constitutional entry cannot be determined with reference to parliamentary enactment. Otherwise, it would result in Parliament enacting and or amending an enactment, thereby controlling the ambit and scope of the constitutional provision. If it is otherwise, I'm sorry, but I missed this phrase, if it is otherwise. That cannot be the law. The power to legislate with which we are concerned is contained in Article 246. The field are demarcated in various entries. On reading both, it has to be decided whether the legislature concerned is competent to legislate when its validity is questioned. The ambit and scope of entry cannot be determined with reference to any parliamentary enactment. Tika Ramji's case is required to be examined in detail, since that has been the bone of serious elaborate submissions in that case. The challenge by the sugarcane growers hailing from several villages of the state of UP was to the validity of UP Sugarcane Regulation of Supply and Purchase Act 53 and notification issued thereunder. A short history of legislation enacted by the centre as well as province of UP in regard to sugar and sugarcane was noticed. Then Lordship omit that. Kindly come to abroad, perhaps para 40. PDF page 1626. On 31/10/51, Parliament enacted the Industries Development Regulation Act 51 to provide for the development and regulation of certain industries. By Section 2 of the Act, it was declared that it was expedient in the public interest that the union should take in its control the industries specified in the schedule. The schedule included industry engaged in the manufacture or production of sugar. The UP legislature enacted Impugned Act. The object of it was as follows. With the promulgation of Industries Development Regulation Act with effect from so and so, the regulation of sugar industry has been exclusively a central subject. The state government are now only concerned with the supply of sugarcane to the sugar factories. The bill is being introduced in order to provide for rational distribution of sugarcane to factories for its development on organized scientific lines, to protect the interest of the cane growers of the industry, and to put the new act permanently on the statute. In exercise of the rule-making power conferred by the Impugned Act, the UP government made rules and also promulgated UP sugarcane regulation supply purchase order. All these related to the supplies and purchase of sugarcane in UP. Challenging the wires of the State Act, one of the submissions made in Tika Ramji's case before the Constitution.
You've seen Tika Ramji, why are you reading this? Actually, if you go to para 61, that's where Justice Sabharwal has summed up what he wants to see. Just see para 61 at 1632.
I'll just, can you give me 1 minute, please?
That will be your internal page 267 of the judgment.
For that.
Sabharwal says this at, let's see Placitum C at page 1632. Placitum C, if you have the same copy. Placitum, Shadan just give it to Mr. 1632, Placitum C, the expression industries
In entry 24.
in entry 24 of list 2 or entry 52 of list 1 cannot be interpreted in a manner that would make other entries of list 2 of the 7th schedule subject to union control, which in fact they are not. Wherever it was intended to be made subject to such control, whether of list 1 or that of list 3, it was said so. A perusal of list 2 shows that whenever a particular entry was intended to be made subject to an entry in list 1 or 3, which has been so stated specifically. Therefore, an interpretation which tends to have the effect of making a particular entry subject to any other entry, though not so stated in the entry, deserves to be avoided, unless that be the only possible interpretation. We do not think that such an interpretation on the entries in question, namely 52 of the union list and 24 of the state list, deserves to be placed. That is really the heart of what the learned judge said.
Right. But this one of the passages, the lordships have dealt with this issue also.
This is a dissent, is it?
No, this is not a dissent.
Oh, this is not a
This is
dissent.
the majority judgment.
Yes.
Now, they have dealt with this issue, that Central Act is not challenged. IDR.
They have dealt with that. He has dealt with that as well. The learned judge says that if and when it is challenged,
No, it's come explicitly. I'll show.
para 64 at page 1633. Shadan, just give it to him.
Give certain other acts.
Para 64 at 1633. The validity of certain other acts, such as Cardamom Act, Central Silk Board Act, Coffee Act, so on and so forth, reference whereof was made by Mr. Shanti Bhushan, need not be examined for the purpose of considering the legislative competence.
I'll paste it. Permit me. The legislative competence of Parliament to legislate these statutes is not in issue before this court, and therefore we do not think it necessary to examine the question of legislative competence only on the academic viewpoint insofar as these legislations are. However, prima facie, there is no substance in the apprehension expressed by Mr. Shanti Bhushan that narrow approach of industry. No, not this one, but this. They have
Just see the following sentence. As and when these acts are challenged.
No, I'll answer that one. because in this case, this question was raised because no one has challenged the Central Act. Therefore, I'll just, kindly give me just a minute.
This two sentence after that, I mean, what the Chief Justice was trying to say.
No. I'm not cut it out and give it to you, not but देख लो ठीक से, carefully examine it carefully. Then it's not like that.
Actually, Tika Ram ji dealt with a process anterior to manufacture, namely acquisition of the raw material, which was sugarcane. They said that the acquisition of the raw material would not be comprehended within the expression of the word industry under entry 52.
Not the end, even the end product.
Right. In our case, entry 8 covers not just intoxicating liquors, but it covers
Production and manufacture.
Possession, transport, purchase,
Everything.
and sale of intoxicating liquor. So, really speaking, entry 8 would cover the entire gamut of entry 52 as well.
That's what McDowell
That's
says.
why a specific entry having been made by the founders of the framers of the Constitution, the entry 8 must govern.
Para 78.
Can you have not para 45? Can you have para 45? Para 45, Lord Lordship would find and in this case they struck down the IDR specification. Even though, can you have para 45? Two, the challenge was to the wires of the state legislation. That is page.
Parliamentary. Yes.
And not to the parliamentary legislation. But at the same time, the entire basis of challenge was that in respect of sugarcane, only Parliament had the power to legislate on account of field being covered under entry 52 list 1. The sugar industry having been included in the entry and the connotation of industry being very wide to include in it raw materials and sugarcane as well. Thus, the exclusive power of Parliament to legislate was urged as the main ground to seek invalidation of the state legislation. The field of sugarcane is not available to the state legislature to legislate. That's what was argued. And 46 word, in view of the controversy as aforesaid, the fact that the validity of the parliamentary legislation was not an issue in parliamentary case, in the Tika Ram ji case, does not in any manner affect the ratio of that decision. The point for determination in that case was substantially the same as in the present case, namely the scope of expression industries in entry 52, list 1 and entry 24, list 2. There also the point was to adopt a narrow or a wide interpretation of the expression industry. Further, the fact that it was a case of manufacturing industry under IDR Act also does not affect the ratio of the case. The interpretation placed in Tika Ram ji cannot be confined to industry falling under IDR Act alone. There is neither any express or implied indication in that decision to limit the scope. Then kindly have 50, which is important. At page 263. 28.
Parliament.
50. The petitioners in Tika Ramji's case in support of the wide construction to be placed upon the expression industry also relied upon various decisions interpreting the said term in relation to Industrial Disputes Act. What we are concerned here is not the wide construction to be put on the term industry as such, but whether the raw material of an industry which forms an integral part of the process are within the topic of industry which form the subject matter of item 52 list 1 as ancillary or subsidiary matters which can fairly or reasonably be said to be comprehended in that topic, and whether the central legislature while legislating upon sugar industry could acting within the sphere of entry 52 of list 1 as well legislate upon sugarcane. This court said that the legislation with regard to sugarcane came within the exclusive province of central legislature under entry 52 of list 1. The enactment passed by the provincial legislature would be ultra vires, it was said. Lordship, may I just kindly come to the next one. Lordships have already seen the gist of all these cases. Now, kindly come to para 57. Para 57. 1630. Mr. Shanti Bhushan, however, contends that once the field is covered by entry 52 by issue of requisite declaration, and Parliament has actually covered the field by enacting a legislation with regard to that extent, the mill industry, including all facets of such an industry, whether it is raw material or the products of that industry, the state legislature will have no power to legislate. The contention is that the expression industries in entry 52 list 1 comprises in it all its aspects commencing from procurement of raw material and up to the disposal of final product of that industry, not only the process of manufacture or production. The submission of learned counsel is that the expression industries in the entries under consideration is not given such interpretation. It would denude the Parliament of the real object of control and such industry, in particular, in public interest, which is of paramount importance. As against this, the contention of the other side is that the acceptance of a viewpoint propounded by Sri Shanti Bhushan would mean denuding the state legislature of the power to legislate in respect manner.
Of Mr. Bhushan were negative.
Negative.
Now come straight to para 78.
Very good.
Why do they say so? Come to 78.
Madam. Science was also placed.
Acceptance of the argument of Mr. Shanti Bhushan.
Exactly. Right. The acceptance of the
Argument.
I'm just acceptance of the argument of Mr. Shanti Bhushan would make various entries in the state list ocious and meaningless, and subject to entry 52 of list 1, despite the fact that the entries are not so worded.
Now come to para 82, where they also relied on entry 54 of the union list and entry 23 of the state list.
Right.
And what is the ultimate finding?
Right. The structure and scope of entry 54 of the union list and entry 23 of the state list and their interrelationship is substantially different from the scope and structure of entry 24 of the state list and entry 52 of the union list. The entry relating to development of mines and minerals has in it both the industry of mines and the product of minerals, and therefore on a declaration both mines and minerals get embedded in 54 of the union list. Therefore, it has been consistently held by this court that the declaration under entry 54, Parliament evinces an intention to occupy the field. Then kindly have the next one too. The Constitution, Wilson Sugar, this is again a Constitution benchmark. The Constitution bench examined the question regarding the legality of levy of market fee under Bihar Agriculture Produce Market Act 1960 pertaining to various commodities including sugarcane, sugar, molasses, wheat and tea. The court first dealt with the transaction of purchase of sugarcane, sugar factories, functioning of the market areas falling within the jurisdiction of respective market committees constituted under the market. It noticed that the market acts have been enacted by the Bihar legislature as per the legislative power mentioned in it by entries 26, 27 and 28 of list 2 of the 7th schedule of the Constitution. The court, however, noticed that the markets dealt with the supply and distribution of goods as well as trade and commerce therein, as it seeks to regulate the sale and purchase of agricultural produce to be carried on in the specified markets under the Act. To that extent, the court said the expression entry 33 of list 3 override the legislative power of the state legislature in connection with the legislations dealing with trade and commerce in and production, supply and distribution of goods. Thus, to the extent to which Markets Act seek to regulate the transaction of sale and purchase of sugarcane and sugar, which are foodstuff and trade and commerce therein, the Constitution when says that the Markets Act have to be enacted under the topics of the Markets has held that it has to be held that Markets Act being enacted under the topics of legislative power under 26, 27, 28 of list 2 would be subjects to any other limitation under entry 33 of list 3. The contention of Mr. Dwivedi, however, that as admittedly tobacco is not foodstuff and does not fall under entry 33 of list 3, like the amendment of the Constitution made in 53, Parliament for further amendment of the Constitution can if so advised, place tobacco raw material of the industry in entry 33 of list 3 and thus confer on it the competence to legislate in respect of tobacco. Need to be examined by this court, need not be examined, by this court as being unnecessary. What we may, however, note that the Constitution bench, after noticing various provisions of the Act and rules, came to the conclusion that need for regulating the purchase, sale, storage process of sugarcane being an agricultural produce is completely met by the comprehensive machinery provided by the sugarcane enacted by the very same legislature which held. Now, Lordship may note perhaps then the paragraph 87, they notice other decisions which have followed this logic. 88 perhaps. The principles aforesaid would equally apply to entries 14, 27, 28 and 66 of list 2. It may further be noticed that in para 170 of Bales and Sugar Companies, the Constitution bench reiterated the view expressed in Tika Ram case and also Seal's case, affirming the full bench of the Allahabad High Court, Shriram Industrial Enterprises. In view of the above, we see no compelling reason, either on account of binding precedent in the form of earlier Constitution bench judgment, history and background of the framing of the Constitution, or other words used in various entries of the language in the Article Constitution of India, to take a view which will result in denuding the power of the state legislature to legislate not in respect of field of legislation under entry and 24, but field of legislation covered by other entries in the state list on making a declaration under 52 of list, union list. The Constitution bench judgment in the case of Tika Ram and other decisions following it confined the field of legislation of industries to process of manufacture, production, not to raw materials which in view of the aforesaid, I conclude as under. The state legislation and the Tobacco Board Act 75 to the extent of sale of tobacco in market area cannot coexist. So, Tobacco Board Act is the central legislation, state legislation and the Tobacco Board Act cannot coexist. The state legislatures are competent to enact legislations providing for sale of agricultural produce of tobacco in market area and their levy and collection of market fee in that way. Parliament is not competent. Can you look at this? Parliament is not competent to pass legislation in respect of goods enumerated in the aforesaid conclusion 2 while legislating in the field of legislation covered by entry 52 of the union list, under which Parliament can legislate only in respect of industries, namely the process of manufacture and education. So even though here parliamentary declaration law was not in question, yet they said Parliament cannot do it. A declaration was issued. But as I said, once the lordships come to the conclusion that the scope of the entries is to be delineated, you can't delineate that in the light of the parliamentary legislation. Then again the question would be under which entry this law falls. And if lordships come to the conclusion that encroaches on the state list, it has to. And that is where the question of lordship in Jain Verma's case, the dominant legislature will always have the power. Despite the fact that there is a parliamentary legislation covering the ancillary incidental.
But Justice Rumapal's judgment from para 110 onwards, a very, very, illuminating.
Doctrine may also have para 94.
94.
94. Which had come earlier, but then I would.
1647.
But 94 is very clear. No?
Right.
Although Parliament cannot legislate on any of the entries in state list, it may do so incidentally while essentially legislating within the entries under union list. Conversely, the state legislature may encroach on the union list when such an encroachment is merely ancillary to an exercise of power intrinsically in the state list. The fact of encroachment does not affect the wires of the law, even as regards the area of encroachment. This principle, commonly known as doctrine of pith in substance, does not amount to extension of the field of legislation. This is important. It does not amount to extension of the field of extension of the legislative fields. Therefore, such incidental encroachment in either event does not deprive the state legislature, in the first case of Parliament, in the second, of their exclusive powers under entry so encroached upon. In the event incidental encroachment conflicts with the legislation actually enacted by the dominant power, the dominant legislation will prevail.
I'll tell you, as we are rising today, that really that is the heart of what we have to consider. That's something which is worrying me, and we're still open on this aspect.
Well, I thought I had closed it down.
No. Just maybe 5 minutes tomorrow on this. Then the process of reflection never stops until the last word is said. Tika Ram ji said that the word industry means the process of manufacture or production, and that it does not include the raw materials used in the industry or the distribution of the products of the industry. Distribution of the products is entry 26 and 27. Raw materials is not covered by entry 52. That is Tika Ram ji. If you come down now to ITC, which we are reading, ITC dealt with the market fee, the market fares, because it was the Agricultural Produce Market Committee. Justice Rumapal and the other judgment, Justice Sabharwal, says that applying the logic of Tika Ram ji, the regulation of markets and fares under entry 28
Are not subject to entry 52.
are not covered by industry.
52.
Are not covered by industry.
Yeah.
Right? And therefore, entry 66, the power to levy market fees is preserved for the states. That is ITC. The real problem which we are, the conundrum which we face is this, that entry 52 covers production, manufacture expressly. Right? Entry 8 covers production, manufacture expressly. So there is a complete overlap between entry 52 and entry 8. Now, one answer to that is this, that if you read, therefore, both of them as overlapping and entry 52 as having predominance, then entry 8 is rendered odious. But where the two entries are so completely overlapping, because both cover production and manufacture, entry 8 expressly, entry 52 by interpretation that we have placed in Tika Ram ji, then what will prevail?
No. Can we have entry 52 once again? For a moment, just a minute. Entry 52.
You see, Tika Ram ji and all the cases subsequently were able to skirt around this issue because there was no absolute overlap. Tika Ram ji was, before, then, this last judgment is after markets and fees. This is a case which is directly and squarely an overlap between the two. That is the problem with
that may not be the correct view of Tika Ram ji. Tika Ram ji, in every case, not right from Tika Ram ji till date, what the union and the petitioners have emphasized is that entry 52 will include not only
manufacturing. Just see para 126 of Justice Rumapal's judgment, para 126, and then we'll rise, then we'll also reflect it upon it in the night. We'll do it again. To sum up, learned judge says, at page 1659.
To sum up the word industry for the purposes of entry 52 of list 1 has been firmly confined by Tika Ram ji to the process of manufacture production only. Subsequently, decisions including those of our other constitution benches have reaffirmed that Tika Ram ji's case authoritatively defined the word industry to mean the process of manufacture or production, and that it does not include raw material used in the industry or the distribution of the product in the industry. Given the constitutional framework and weight of the judicial authority, it is not possible to accept the argument canvassing a wider meaning. But this is the critical.
Just go ahead.
To accept argument canvassing a wider meaning of the word industry, whatever the word may mean in the other context, it must be understood in the constitutional aspect as meaning manufacture or production.
Now, you see para 127.
Applying the negative test as evolved in Tika Ram ji in this case, it would follow that the word industry in entry 24 list 2 and consequently entry 52 of list 1 does not and cannot be read to include entry 28 and 66 of list 2, which has been expressly marked out as field within the state's exclusive jurisdiction. But this is the
Go. Just read that para. When we'll read.
As noted earlier, entry 28 deals with markets and fairs and entry 66 with the right to levy fee in respect of, in present context, markets and fairs. Entry 52 of list 1 does not override entry 28 in list 2, nor has entry 28 in list 2 been made subject to entry 52, unlike entry 24 of list 2. This court in Belson has also accepted the argument entry 28 of list 2 operated in its own and cannot be affected by any legislation pertaining to industry. But this part...
Now just see para 128, just one sentence. If industry does not include markets and fairs, it is important to define what markets and fairs connote. Then learned judge discusses it. Therefore, all these judgments really say that, look, entry 52 does not cover the activity which is being legislated upon by the state. And therefore, in one case, raw materials, the state can legislate. Markets and fairs, the states can legislate. We are now in a situation where both are exactly on all fours together.
Have a relook.
Production and manufacturing.
Let's have a relook at Calcutta Gas and McDowell.
Then what happens?
There they are dealing with industry.
Huh.
In Calcutta Gas, Constitution Bench was dealing with industry, gas and gas work. Entry 25 list 2.
There are two possible answers. One is to say, which is the pro-state, we say the pro-federal principle, that if the entry is not made subject to a central entry, then the state entry must have its full operation. The other is to apply, though the Constitution is federal, the Constitution is federal with a certain weight in favor of the center, and then say that whether two entries overlap, then Article 246(1) will prevail. Because they cover exactly the overlapping field. There are two opposing viewpoints. Question is which one to adopt.
Fair enough.
What do we do?
I'll come back tomorrow morning with fresh ammunition, perhaps.
Another tentative answer, if I may offer.
Sure. Yeah.
Just one second, brother.
Chief Justice has given you a lot of food for thoughts, Mr. Dwivedi.
Definitely not, but
I may provide you some drink for thoughts.
That's what.
Some drink for thoughts.
Well,
We are talking about different intoxicating liquor. Some require aging, some does not require aging.
right.
Some are fair, some are dark. But perhaps it may not be comprehensible to some members of the bench. Would material exhibit help?
The best thing would be not to send a bottle to each one of the
All in lighter way.
I told Brother Jamshed as we were rising for lunch that you have become a domain expert by Mr. Dwivedi's argument.
May I please not?
But I'm certainly, I must admit, I'm fond of liquor, but I don't mind claiming that.
I seek my lord.
But in a lighter way.
Material object shall remain
We had a trademark case. So we bought actual bottles, we bought to show the code. And went for lunch. We came back for lunch, they were all the entire consumed.
I seek my lord's leave, my lord.
We repeated the code.
May I seek my lord's leave, my lord? My lord, in this matter, I am appearing for UT of Puducherry, my lord. The registry is not accepting my bakalan. I may be permitted to tell.
Yes, of course.
Obliged.